Hello, Dr. Dana Tassone here with participants in HFT 6228, a graduate course in hospitality management, and we're discussing Chapter 4. Chapter 4 is concerned with written law called statutes, statutory law that impacts the operation of human resources within an organization. Hopefully by now, and as you know, previous chapters, particularly the last chapter, started leading us up to legal doctrine thinking. We discussed in the last chapter the origins of tort law, common law, unwritten law, case law, all the same thing. And today we're talking about statutory law, legislative written laws that govern in civil actions. And in our case, it's all a matter of civil law. What's civil law? Civil law governs the actions between individuals and entities, as opposed to criminal law, which has to do with crimes against the state, actions against the statutes of the state. So these are civil statutes, and in the chapter, we go through about 32 years of statutory law, which are still the laws of the land, and it's important to understand that there really are two aspects of human resource management that are dynamic in that they change consistently. One is the legal environment, and the second is compensation practices. Why do they consistently change? Because new regulations are established that impact those practices. For instance, when it comes to compensation, which we're not there yet, but when it comes to compensation, the sample paper that you have on your homepage is an update that brings us to the current state of compensation practices, in particular in the state of Florida. And the second area, of course, is the legal environment, which is dynamic. And so, since the writing of this book, there have been small number of newer statutes created, and for testing purposes, of course, individuals are only responsible for the information cited in the text. However, I will provide updated information for those that have an interest in that area. Also, it's not important for testing purposes to know the dates of specific statutes. However, it is important to be able to recognize the statutes by their acronyms. So if we talk about the Civil Rights Act, we're talking about the CRA. So that's how we'll recognize it in a written test. Age Discrimination and Employment Act, ADEA. So that's how those items will be referenced in a test. So in the scope of civil law pertaining to employment, and as we know, that the general public became aware of this social scenario during the early 60s, when civil rights appropriately became an important issue in all aspects of society. However, most people don't know that when it comes to employment, the first civil rights legislation, interestingly enough, called the Civil Rights Act, was established in 1863 during the end of the Civil War. And to this day, the coverage of that statute is still invoked in matters of dispute. So the law that everybody knows about is the Civil Rights Act, CRA, 1964. But in fact, to this day, individuals will pursue standing under the original Civil Rights Act, which was in 1863. Also, the way the laws are presented to you in the text is chronologically. So it starts with the oldest statute and moves its way forward about 32 years later. So, and here's another thing to know, that these statutes identified in the book are federal statutes, which means they apply across states. However, it's important to know that individual states have specific statutes that replicate and enhance the coverage of the federal statutes. So if you have a federal law called the Civil Rights Act, and that law prevents against the discrimination of individuals based on race, sex, religion, national origin, and what they called color. In let's say in the state of Florida, there is a replicated law that provides protections against those same protected classes. We don't use the word minority, we use the word protected classes within the state. And in this state, they provide agency administrative powers to specific counties. So in this state, you'll not only have the federal law, Civil Rights Act, you'll have the state law, Civil Rights Act, and you'll have the county law, Civil Rights Act. And whenever we see duplications of statutes, it's as it moves to different levels, the entity cannot decrease the coverage of the law. It can only increase it. And in fact, in the state of Florida, the law covers aspects of discrimination beyond what the original federal law covers. And so let's say a person feels as though they've been discriminated against, and as you know, the agency that handles that at the federal level is the EEOC. And in this state, an individual could also bring action through a county board, usually in this state called the Human Relations Board. And so when a person files a claim, they'll file it both with the EEOC and with the Human Relations Board. In fact, to make it even easier, the EEOC and the Human Relations Board will occupy the same office. When a person files a claim they feel as though they've been discriminated against, then the person becomes what is called a complainant, and the person is complaining against the organization, which becomes the respondent. And as time progresses and it moves to, let's say, court aspects, then the complainant becomes the plaintiff, and the respondent becomes the defendant. And so you're given a list of the basic laws. You're given a nice, concise provision of the coverage and the exceptions to each specific law. And it's important to know that in the beginning, when the legislators developed the Civil Rights Act of 1964, as amended, by the way, these laws are amended continuously, the legislators did not really know what discrimination looked like. They just said, "Thou shalt not discriminate based on race, sex, religion, national origin," and And so they write the law, and what do, as you were told in the last chapter? They empower an agency, and the agency consists of technocrats, which is done for any act or any law that's written, and the technocrats are provided with powers that are enhanced beyond the traditional balance of powers that we have been taught. So, in this case, the agency, speaking in administrative law terms, the agency is, let's say, the EEOC or the ex-county Human Relations Board. The agency possesses the power of enforcement, similar to the administrative branch, the power of interpretation, adjudication, similar to the judicial branch, and interestingly, the power of legislation. They can actually generate their own rules, as you've seen in the chapter. So they contain all those three powers, which makes them very powerful. And of course, where's the check and balance? Hypothetically, the check and balance lies with the legislative branch. Legislators create the act, the legislators create the agency, and the legislators can have what is known as the power of the purse over the agency, and they can revoke the existence of the agency and certainly revoke the funding of an agency at any time. So they make a law, this very, actually it was the second, but this law, the most well-known law, and they said, don't discriminate based on these factors. And so of course, in the beginning, individuals brought claim, and claim became suits, and the suits were interpreted by the courts, and the landmark court case that really told us what discrimination looks like was called Griggs v. Duke Power, and really a very holistic case, and what that case in essence did, and there were other landmark cases that added to this, but what the Griggs case did for us was establish the four theories of discrimination, the four legal doctrines of discrimination. And the first doctrine is called disparate treatment, sometimes referred to as adverse treatment, whereby an individual is treated wrongly based on his or her protected class status, and he or she incurs harm, and the entity, in this case the organization, and the entity discriminated against the person intentionally. They meant to discriminate against the person based on the protected class status. That's disparate treatment. And the second doctrine is disparate impact. Well, disparate impact is virtually the same thing. The organization did discriminate against the individual. It did discriminate based on some protected class status. However, in disparate impact cases, intent is not an issue. So if an organization discriminates unintentionally, the person, an individual, a claimant, if you will, has standing under the doctrine of disparate impact. Could there possibly be a case involving both disparate treatment, intentional, and disparate impact, not intentional? Absolutely. Happens all the time. So those were the two big ones, and those were the two preclusionary descriptions, if you will. But those were the ones that said, "Thou shalt not harm." That's what they were about. As time goes on, or no, even in the same case, we learn about a third, or the court established a third doctrine, and that is the doctrine of accommodations theory. So, disparate treatment don't hurt anybody. Disparate impact don't hurt the whole class of people. And now, accommodations theory. Not don't do harm, now it's accommodate individuals represented in a protected class. And to what degree must an employer accommodate those individuals? To the degree of reason. And what is reason? Reason, legally, is defined as that which an individual, thinking reasonably, would do under the same or similar circumstances. That's reason, which leaves the doctrine of reason to be wide open for interpretation by the courts, and as everybody has a tendency to do, we have a tendency to quantify things. So in the case of accommodation, the courts will look at the earnings of an organization, look at the total revenues of an organization, and they will set up a dollar figure that is deemed to be reasonable for that organization. And then over the years, as you can imagine, not surprisingly, that number gets higher and higher and higher. And so reasonable accommodation now is pretty expensive, in the hundreds of thousands of dollars. And then the final theory, the fourth theory, is, and they're not in any order, but the fourth one that I'm telling you about is the perpetuation theory. And bear in mind, the legislation was attempting to legislate actions that are really morally correct. Don't hurt people based on these things. And so the courts recognized that some people may have a policy, a practice, that in fact perpetuates prior discrimination that occurred prior to the enactment of the law, and which was a brilliant doctrine to establish. And the question today is, that was 40 some years ago, those perpetuations still exist, and you know the answer to that. Of course, it still exists, and so it's still a viable doctrine. So, in the case of statutory law, we recognize that the legal doctrines that were just explained are still very much in force. As a matter of fact, that they immediately get called upon when a case goes to court, and that newer, as the legislative process increases over time, the newer statutes become more geared toward the accommodations theory than the other theories to not harm an individual. And again, to point out the disparate impact, disparate treatment, and perpetuation, those are all do not harm. It's the accommodations theory that says, you must accommodate. An individual or organization must accommodate. So, and of course, the chapter gives you all the specifics of the coverage, the definition of protected classes, in particular, what became a very hot issue, as you know, sexual discrimination. The individual, interestingly enough, who took the strongest stand in establishing a case law doctrine concerning that was Justice Clarence Thomas, and it was an interesting history behind that. You can Google that if you like. Now, those are the laws, and those are the coverages. What are the exceptions in the field of law? you have the coverage, and you have the status of it, and then you have exceptions to the law. In other words, what defense does an organization have with regard to the law? And the two major ones, and they're very, very, very simple. The two major ones is a BFOQ, bona fide occupational qualification. I had a professor one time who would berate us by saying that wrong. The correct Latin pronunciation would be bona fide, and he would yell it to us, bona fide, and we would have to yell it back to him. Anyway, BFOQ, and the other one is a business necessity argument. So those are the two exceptions. So an organization, claim is brought against an organization, and the organization in defending itself will view those two exceptions as an attempt to provide a defense against the allegation of discrimination. And it's important to note that these two arguments are not to say it didn't discriminate the organization. They say they did, but they had to because. And it's also important to note that there are no exceptions, no BFOQs, and no business necessity exceptions for matters of race. Never. I think we're out of time. That's chapter 4 in a nutshell. There will be a thread of law running through the next few chapters. In particular, we will get into tort law, unwritten law, common law, which is a really interesting, in my opinion, interesting area. And in my practice, by the way, that you're an HR. When I was a HR director and later an HR VP, that was my job. Other than overseeing all the other specialties, all the other specializations, my job was to handle the legal issues. Could I have farmed that out to a specialist? Absolutely. But I had a budget. We all do. And I chose to use my budget dollars more for human development, training, those types of things, as opposed to. That's not to say that I didn't. We always kept attorneys on retainer, and maybe somebody might want to ask me about why attorneys aren't or shouldn't be HR directors or VPs. As a matter of fact, when I became a VP, I replaced an attorney who had not done so well. But that might be a discussion for a later time, and we're definitely out of time. Thank you.